I think the issue is, as a solicitor, with the advent of CFAs, that it's forgotten that the money belongs to the client.
Absolutely.
The costs are the client's.
Absolutely.
And they need to account to the client as if they were taking the money out of their own pocket, and they forget that.
Absolutely.
That gets forgotten.
And have CFAs, in particular the reforms, have they focused people's system minds so much on maximising the compensation they can get, or the fees that they can deduct from damages, that they're losing sight as well of their obligations?
I think a main crunch point was when the law changed in relation to recovery of success fees and recovery of AT agreements. Because in the early incarnation of conditional fee agreements, the party paying all of the costs, paying the success fee, paying everything, was an insurer. And the insurers were big enough and ugly enough to negotiate their own costs and to get the best deal that they possibly could. When recoverability went out of the window, I think Victoria's absolutely right. The solicitors forgot that element that they were taking out of compensation was the client's money. And there needed to be proper informed consent about how that was initially calculated and how it was presented in the final bill, rather than just being taken from that pot of money that was sat there and available.
And just following on from that, there is a general misunderstanding of how the success fee is calculated as well.
Absolutely.
Particularly in the personal injury market. It's just a case of we can take 25% of your damages. And they just don't necessarily understand how the process should work, which should be a reference to the basic charges. And that's something that actually I addressed at the ACL conference, is the fact that the cost training isn't given to solicitors in any of their training experience, which is just astonishing. So there's a complete lack of understanding of the process. And as I say, they've just forgotten the cost belongs to the client, and then they also just assume they can take the 25% success fee.
It's simply not covered in the training course.
No.
At all.
You mentioned District Judge London before, because he's had a go at a firm not far from here.
Indeed.
And let's be honest, I'm sure they're not alone in what sounds like it's just a way of operating, and it's not necessarily malicious or anything like that, but it's become a standard operating that 25% is not a cap, it's the figure, and you make sure that your system, that your base fees are such that you're always going to get the 25%. Is that the prime issue that you come across?
Absolutely. There was a model that was promulgated by someone who I won't name about 20 years ago, that suggested that solicitors ought to inflate their base costs with a view to always ensuring that 25% of compensation can be taken. But we now see even more egregious examples where 25% will be taken in respect of the success fee, and another 20% will be taken in respect of the difference between solicitor and client costs and recovered costs. So these clients are losing 45, 55, we've even seen 65% of compensation being taken out of the pot of compensation.
Oh, they can do that.
Yeah. Contractually, if they've got a contractual terms, they can, and it's been explained. But that's going to get worse as we see the fixed recoverable cost back more and more, because law firms are saying that they need to enforce the shortfall, which they never did when the costs were recoverable between the parties. Then they need to enforce the shortfall in order to stay viable.
I think this sort of feeds into something we put in the Office of Good Cost Service. Nice opportunity for you to advertise that.
Indeed.
Following the Herbert ruling, this point about the departure from the orthodoxy in terms of charging, the basis of charging, the concept of taking into account all the relevant factors to what you're going to set your success fee, that should still be relevant. And if you're departing from that, particularly if you're departing substantially from what it should be, your client needs to know not only that that's what you're doing, but also that other firms out there might charge you a lot less for this work.
Yeah.
And that's been our position for a few years. And indeed, when we did the most recent edition, which was 2023, in fact, after a case called Belson or something, I might have heard of it. Then, yeah, probably. So that's the principle ultimately, that when we don't have a particular beef with firms that want to make money, you know. But the point is, if you're going to do it at the client's expense in circumstances where they need to know they're being charged significantly more than they might get elsewhere, and there might be a good reason for that. We're a really good experienced firm that specialises in this particular area. You're going to get the very best service. There's a service level agreement that competes very well with everybody else in the market. That's what the price is for. But if you're not doing that, and you're offering to the clients what looks like a standard terms and business, this is how it's done, and the client's going into this with closed eyes, that's not informed consent.
I mean, is there, Lord Justice Jackson expected there to be competition. Is there competition due now? Are there any firms that will say we'll do it 15%?
The only competition I see is the amount of shortfall that isn't charged. The success fee tends to be same across the board.
But I don't think that's publicised.
Oh no, I don't think it's publicised. But that's just my personal practice.
In what way do you mean?
Well, so some firms will charge a shortfall up to a cap of 65%, and some won't charge a shortfall at all. Some say they can make it work. I mean, there's one particular firm not far from here that makes it their mission statement that they don't see any reason to charge any shortfall at all. They're going to make it work on the fixed recoverable costs, and that's their stance. And that is making trying to make a quest for that to be adopted throughout the process, throughout the profession. But because he thinks that the fixed recoverable costs are enough to still keep it as a viable business, as long as they're.
So there is competition.
Well, that's one firm.
There's one firm.
I mean, I'm not professing to know all of them, obviously.
But in your obviously things, you only see the ones. Do you ever see the good guys? Do you turn cases away because you've actually said? No,
absolutely. We turn cases away where people have been given a proper explanation whether a charge is reasonable and has been explained. But there's a point, because I think Simon made a good point about the sort of Herbert explanation that's required to go into the success fee. And one of the difficulties is that the secondary legislation in relation to these cases. So if you look at the difference between damages-based agreements and conditional fee agreements, in relation to a damages-based agreement, because the wording of the regulations is slightly different, there is binding law at appeal level that says that when setting out the percentage that's to be charged in a damages-based agreement, the agreement must itself include, on the face of the agreement, an explanation as to why it's somewhere in the range of 0% and 25% for personal injury cases. And the explanation might be, as Simon implied, we're a fantastic firm, we do a really good job, and we think we merit 25%, but you might be able to get it cheaper elsewhere. Now, that requirement to explain the percentage isn't part of the regulations that now cover conditional fee agreements. So, as the Court of Appeal said in Herbert, the explanation that can be given in a CFA case is just, we charge 25% on everything. Explanations given, absolutely fine, but it doesn't have to be. There's no requirement to explain why within the available band, which can be between 0% and 25%, your particular case has been set at the point that it has been. And that would be a really useful piece of information, I think, for clients in personal injury cases.
Really, there's nothing deliberate, that's just poor drafting of the regulations.
Yeah.
But just to clarify, the success fee might be set at 0 to 100%, the cap might be 0 to 25%. So I know we know what we're talking about, but just to clarify. But isn't that arguably relatively easily overcome?
Absolutely.
If they follow the guide to a good cost practice and have all the cost information in one place and just send you that?
Okay. There you go. You can see the costs were discussed. I mean, can I? You know, and that's it. Because the process is done. That I've had the conversation, and they might have been brilliant, but they're out bugger all then.
Yeah.
And it's like, what do you want me to do with that? Because your client is saying you didn't explain this really important part of the cost. You didn't tell me about the success fee or how it's calculated. Or I know we did all that.
Yeah.
I mean,
we can't prove it.
Well, I mean, we need to draw to a close, but if only someone would come up with a digital system.
Oh, well, thank you. Absolutely. Indeed. Right, well, so I'm just going to, thank you, Neil. Have you finished? There was one question I'll ask Mark after. I want to know which case he regrets taking. A public case he regrets taking, if there is one. But have you got a quick answer to that or not?
No.
Well, okay, fair enough. Okay, so it just remains for me to thank everybody for coming today, but mainly Neil, Simon, Mark. We've had quite a passionate conversation about the client's right to know, informed consent, the price of law, transparency, trust and vulnerability. Thank you very much, everybody. Thank you.